What we're trying to do today is to tie up some of the loose ends, some of the things that we have gone over, and some of the things that are perhaps still new to most people. Many people are not aware that the interpretations of our constitutions by the Supreme Courts, whether you're talking the state Supreme Court or the federal Supreme Court, we have a man named Joseph Story, who was a Supreme Court judge back in the 1820s and so forth, but his thing was that the power to interpret the Constitution is also the power to misinterpret the Constitution. And what he was afraid of is that the day might come when the Supreme Court would begin to interpret the Constitutions and actually misinterpret the way it was written. So the biggest problem we have is sometimes the way a law is written, including our own constitutions, are simple. You should be able to read it and say, this is the way it is. But that is not the case. Today, the constitutions, whether you're talking the state constitutions or the federal constitution, is absolutely meaningless. It's the interpretation that we go by today. And the interpretation, for example, in the year 2000, the Supreme Court interpreted that they had the power to select the president. So they completely stopped the recount that was going on in Florida and just set aside all votes and selected the Republican candidate. There were 5 members on the Supreme Court that were Republicans, so they just gave it to George W. Bush. And the interesting thing about it is that later on, of course, it was determined that Bush did not win the election, but that did not matter, because once the Supreme Court made the decision, all Americans accepted it. And yet there is nothing in the Constitution of the United States, nor in any state constitution, that says that the Supreme Court has the power to select the president. But as we know today, Donald Trump is trying to get his case before the Supreme Court because he now has 6 Republican judges to 3 Democratic judges. And what most people are unaware is the courts are probably the most biased institutions in government, because everybody knows how many Republicans and how many Democrats are sitting on the courts. Whether you're talking state courts, federal courts, at all levels, we all know who the Democrats are and who the Republicans are. And from time to time, it changes. You'll have more Republicans, more Democrats. But the point is, the courts are not unbiased. They are totally biased. And in favor, first and foremost, they favor the profession, the judicial legal profession. They will protect that. It is sacrosanct. It literally is a sacred thing to them, because their power, their positions depend upon that particular monopoly of power. I wanted to go back over some of the things that we've talked about. Most people are unaware that there was a time when citizen lawyers, possessing primarily moral values, things that they had picked up as children and brought with them into their professions, that was prior to the 1930s. From there back in history, citizen lawyers were the lawyers. And that's why you had Abraham Lincoln, who literally was a citizen lawyer. Today, if he tried to practice law with the background he had, he would absolutely be arrested. But so would Clarence Darrow, so would so many other great citizen lawyers, because they've never been judicial lawyers. They didn't go to law school. And a few that did go flunked out or could not hold up under the financial burden of law school. But what I'm showing here is up until the 1930s, 100% of all citizens passed the bar by virtue of their citizenship. That was what qualified you to become an attorney. That was what we had prior to the 1930s. We had certain things prior to the 1930s that led to the history of the changes. One of them, of course, World War I. That was a major turning event in world history. And then you had some other things in America, like the Dust Bowl, which affected 22 states. It literally created a diaspora of people from these Dust Bowl areas. Farmers went under by the hundreds of thousands. Millions of people were displaced by the Dust Bowl. And then, of course, we had this wonderful thing called a worldwide depression, which everyone is aware of the depression occurring, but the reality of the depression was harsh, extremely harsh. And then you had, of course, the rise of Adolf Hitler, and you had the rise of the totalitarian states, Japan, etc. All of these things led to a crisis of faith in America, and it led to a crisis of faith among citizen lawyers. The Bar Acts did one thing. It outlawed the citizen lawyers. Citizen lawyers no longer were allowed to practice. Now, only judicial lawyers, those attorneys that have been pre-selected for law schools, trained within law schools that have a curriculum approved by the courts, and then they have to take a test called the state bar, and then they are monitored by the state bar for the entire lifetime of their practice, meaning they are exactly like those who serve in the military. In the military, you have those who serve in the executive branch, and they are pre-selected for the military, they are trained in the military, and they serve in the military, but not for their entire lives unless they choose to become officers such as captains, generals, etc. They actually do stay in, but they're not allowed to serve in any other branch of government. But what's interesting, judicial lawyers are. They are pre-selected, trained by, and monitored for their entire practice by the courts. And yet, they are allowed to serve in any branch of government. But no one else in any other branch is allowed to serve in the courts. During the 30s, we were working towards something that existed probably all the way through the 40s, 50s, and even into the 60s, and that was called a large middle class. The middle class had a structure and a democracy, and that's the reason why access to the courts was granted for many years until the citizen lawyers began to die out, began to retire, which happened during actually the 60s and 70s, because they had, even the young citizen lawyers had now become elderly, and they left the practice. And all that we had left were the judicial lawyers. No one else was allowed to practice. No one else is allowed to be licensed. And the courts control it through the State Bar Acts. Those are the laws. Now, what's interesting is because of these acts, it also biased the courts. It biased the courts in favor of only their type of lawyers, judicial lawyers. They absolutely outlawed citizen lawyers. I am a citizen lawyer. I studied law. I have written contracts for millions of dollars. I have done many, many things that attorneys have done, but I had to do it on behalf of others, but I could not do it as a citizen lawyer. If I tried, I could spend up to 5 years in prison. Those are the laws. What happened is this 100% inclusion of citizens in the 1930s became the funnel. And you had this large funnel where all the rights of every citizen, their access to the courts became a funnel where all the rights that were coming straight down now channeled through the judicial legal profession. The laws and the constitutions no longer applied. Only the interpretations of the Constitution. And there were people, including myself, that tried to bring lawsuits in the courts, but we were looking for an unbiased judge. They don't exist. Anyone who attacks the legal profession itself, even the biases of the courts simply just say you have no standing, and they just throw out the case. Today we have biased courts, and primarily they're biased in favor of the judicial legal profession, but they're also biased in terms of Republican and Democrat. They are constantly bombarded with the biases that they bring with them into the courts, and yet they no longer step aside. They no longer believe in an unbiased court, because all courts are biased, because they're biased to the legal profession. Biased courts also brought with them something else. They brought in ethical values. Citizen lawyers operated under moral values, values that they learned in their childhood, values that they brought with them through the years, and they practiced using those values. Today, only ethical values are allowed. And ethically, you can do almost anything as long as you don't break, you do not allow your behavior to exceed what the courts require. That is the system. And that also established a monopoly. In other words, our courts, our judiciary is controlled by a small percentage, in fact, it's not even 1%, of the population. In other words, our judiciary is limited today to 1/4 to 1/3 of 1%. I believe it's probably closer to 1/3 of a percentage point today because we have more lawyers. In fact, many people know if you want to get rich, become a judicial lawyer. It is interesting to note that history has played a part in the passage of the State Bar Acts. People lost faith during the time of World War I, during the time of the Dust Bowl, during the time of the Depression. There were so many shattering events that were going on at the time. So many of the citizen lawyers decided they would form an exclusive group to protect and to rule out competition in the future. And that is the reason why the State Bar Acts were passed. And that is the reason why they continue in existence. For one thing, you would believe that no congressman, no judge would be able to make decisions regarding something that affects literally their wealth and power. And yet they do it routinely. They have access to the courts and no one else is allowed. We had a crisis of faith in our moral values, and it was swapped out for ethical values. But ethics relate to wealth and power. Moral values equate to peace and harmony within families, within communities. That was jettisoned in favor of this. What we need to do in order to resurrect citizenship itself is restore the constitutions via the written word. They're very simple. They are not complex. It does not require a great deal of legal education in order to read these things. But it requires something that most people do not have, and that is loyalty to the judicial legal profession. And that is where the courts and the judges come in. They literally are members of the judicial legal profession, and they will maintain the wealth and power of themselves and their fellow judicial lawyers. And that is not going to change because they cannot allow it to change. Therefore, citizenship will always be restricted, and you'll have class structures. We need to restore our constitutions via their written words versus their Supreme Court, whether you're talking state Supreme Court or federal, the interpretations. The interpretations have gone so far as to say, well, they actually have the power to choose who is president. Throw out millions, tens of millions of votes if they so choose. And that is what Donald Trump is banking on right now. If he can get it to the Supreme Court, where he has the primary majority of Republicans, then they will simply appoint him to his second term in office. And that is the reason why Mitch McConnell and Donald Trump have been trying to stack the courts. But they're having problems with this because they misunderstood one thing, and that is that they are loyal to wealth, but they also are loyal to the power of their profession. And that is where Donald Trump has had the advantage of wealth and has had hundreds, perhaps thousands of lawyers. But the point is, they still are loyal primarily to their profession, not to his wealth. And that is the reason why today he's having trouble in the courts, because his wealth is not translating into a win for him in the courts. Because you also have a president-elect and a vice president who are judicial lawyers themselves. How that is going to work out, we don't know. But we need to restore our rights to equal access to the courts. The problem is we do not have equal access to the courts themselves. Wealthy citizens have indirect access, but ready access to the courts. Separation of powers has been completely set aside, no longer exists for judicial lawyers. It exists for every other citizen, but the courts and the judges interpret they are exceptions to the Constitution. There were promises made in the Constitutions. There were promises that should have been kept, but they no longer are. And that is the problem. We have lost faith in our systems because we know they're broken. We know they have been interpreted out of existence. And what you read in the Constitution, whether you're looking at the state Constitution or the federal Constitution, the United States Constitution, it's meaningless because you have no power to interpret what you're reading. And yet what you're reading may sound simple, but it is no longer simple. The interpretations have led the courts to give power, huge power, to judicial lawyers. It's not just in the election of 2000, but also, here's an attorney named Jerry Spence with Justice for None. And what he's talking about is access to the courts is only through the judicial legal profession, his profession. And he, during the time in which he wanted to become wealthy, worked for insurance companies. And he was the one that came up with what was at the time called the Spence defense, which means delay payments. Delay payment on insurance claims, delay payment for death claims. A woman, for example, who had a $100,000 policy on her husband, if you delay paying her long enough and she has to get a lawyer and pay money out of pocket, and the years go by, she will probably settle for half, $50,000, perhaps $25,000, because the courts themselves are delayed by judicial lawyers. Judicial lawyers have access to the courts, and through that access, they can delay anything. And Gerald Spence took advantage of that, and he became quite wealthy. Later on, he kind of felt guilty, and that's the reason why he began to write these books and began to notice that we have justice for really no one. But actually, he's wrong. He has justice for himself and his profession, but that is only about 1/4 to 1/3% of the population. We're talking so few people have actual full citizenship rights anymore. And that's the reason why we perceive the swamp, because the swamp does exist. It exists because citizenship, we ended the rights of citizenship. And today, that is the nature of our system. Will it change? Probably not in my lifetime, but I try. That's all any of us can do, is try. I believe that equal access to the courts is the right of all citizens.